Lordship, the difficulty is that in my suit, I'm not able to get any interim protection because of this order. And the MA is with respect to that only, Your Lordship.
What you have been doing all these years?
Lordship, we were
10 years.
Lordship, we were genuinely making attempt to impress the court that there is a violation of the status quo order. You please grant us protection. You stop them from developing the land. We have filed 3-4 applications. It is a matter of record, Your Lordship. But in being influenced by the earlier stay order in another suit, my applications are not being entertained. There is no order on merits rejecting my application. Every time my application gets rejected for this reason only, Your Lordship. That because there is a status quo order in another suit. I am the defendant, Your Lordship, and this is a suit by the plaintiff.
What is the impugned order?
And the application for recall of the order has been dismissed, Your Lordship.
Recall of the order?
Yes.
Under 47 Rule 1?
No, Lordship, 151, Your Lordship.
151?
Yes, Your Lordship.
So the provision will apply the same? Recall of the order under what provision?
Lordship, the difficulty is that, Lordship, let me explain the checkered history of the case, Your Lordship. Lordship, in this suit, out of which this miscellaneous petition arises, I am the defendant in that suit.
How the order is recalled in the trial court? Under what provision?
Lordship,
Order 47, but it would amount to time, but that's why 151 has been filed.
Whatever it may be, you say whatever provision, but what analogy would be applicable?
Lordship, I am praying for exercise of inherent powers because looking into the peculiar facts and circumstances of the
inherent powers are exercised in absence of any power which has not been given under the procedure. When there is a procedure, what inherent powers are going to be exercised by the...
I am not asking for review of the order. I'm calling for asking for the recall of the order.
What is that?
Lordship, let me explain, Lordship.
What is that?
Let me just explain my case, Your Lordship. Lordship, in this case, this is a suit by the plaintiff. With respect to the same subject matter, the same property, I had filed an earlier suit, Your Lordship. In that suit, Your Lordship, I had prayed for cancellation of the power of attorney as well as the sale deed by which they have gotten the property.
In the earlier suit?
In the earlier suit. So, that suit was going on. In that, I had filed an application under Order 39, Rule 1 and 2, Your Lordship. That application was pending, Your Lordship. During the pendency of the suit, Your Lordship, rather than bringing a counterclaim, they filed a separate suit in which they are asking for a declaration of title over the same property, Your Lordship. That suit is the subject suit out of which this petition arises, Your Lordship. In that suit, Your Lordship, because I had an earlier suit, I filed an application under Section 10, Your Lordship. Because my suit is earlier in time, the property is the same. So I prayed that that suit may be stayed at that point of time, Your Lordship. In that suit, during the pendency of my Section 10 application, they filed an application under Order 39, Rule 1 and 2. Admittedly, after my application, Your Lordship. The trial court first decides their application, grants them status quo, not injunction, only status quo, and then decides my Section 10 application and stays the suit, Your Lordship. Now, because in this suit, there is a status quo order in their favor, my applications for injunctions in my earlier suit, which were earlier in time, keeps on getting dismissed, Your Lordship. The connected MA is arising out of one such application only, Your Lordship. The reason cited for dismissal of my injunction or status quo applications is that because in the other suit, they already have a status quo order in their favor. So, Lordship, the difficulty that I'm facing right now in my suit is, which is an earlier suit, is that in that suit, Your Lordship, I'm not able to get any interim protection. They have a status quo order. Misusing that status quo order, they are developing the land, Lordship. It is a different question whether the status quo order permits them or not. But, Lordship, I want to take some interim protection on that. And that is why I filed application under Order 39-1-2 read with 151. 3-4 applications I filed in my suit.
इनकी भी allow कर देते हैं? दोनों जना enjoy करो.
Lordship, one submission, Lordship. One submission, Your Lordship. The reason why I filed for recall of that Section 10 order is, Your Lordship, because I want that the suits may be consolidated and be tried together. It is arising out of the same property. They are asking for a relief, which if they get, my relief will go, and if I get the relief, their relief will go.
But that is not a correct procedure. If you are aggrieved by Section 10 order, then you should come here.
That is the finding of trial.
Lordship, the trial court has not given
any. How it can be recalled?
Lordship, the trial court has not given any finding. May kindly refer to the finding, Your Lordship.
Trial court can exercise the power under Article 227.
No, Lordship, it is.
Then they have to exercise the power under what? 47.
Lordship, under 151.
151 inherent powers cannot be for the tomorrow you will file an application in the executing court. This court has filed a judgment and decree. Recall it.
No, Lordship.
The whole hierarchy will go.
No, Lordship, that is certainly not the case. But Lordship, may kindly see the impugned order for a minute.
Any order. Either you file a review under 47 Rule 1 saying that this comes within the purview of 47(1).
Yes.
Error apparent on the face of record. There is only one question. Inherent powers, how it can be recorded?
Lordship, the Supreme Court has held in numerous cases that power of recall is inherent in the court, Your Lordship. And if I am able to satisfy the court that this is a befitting case for exercising power of recall, Your Lordship.
What are the ingredients?
Lordship,
Even in 151, suppose that you say that this application is in the headings of 151, comes within the purview of 47(1), then we can understand.
that is why, Your Lordship, may please kindly peruse my application for a minute, Your Lordship. That application is, Lordship.
But even the question would be that whether exercising power under Order 47 Rule 1, order can be recalled. This can be corrected.
Lordship, that is the difficulty.
If there is an apparent error on the face of record.
That is the reason, Lordship, I have not gone in review, Your Lordship, because it is not a case of error apparent on the
But
record.
smart enough to invoke the provisions of inherent powers of the court for recalling that order instead of coming here.
Lordship,
I will give you liberty.
Lordship may just kindly see my application in imputed order for a minute. I'll bow down to that after. Lordship, it is page number 60, annexure P7, Your Lordship.
Page number?
60 P7, Your Lordship.
Yes. 60.
Lordship. Lordship, paragraph number 6.
Paragraph number 6.
That is on page 61. I have written, Your Lordship, यह कि प्रतिवादी की ओर से प्रकरण क्रमांक 1021A of 2014, this is my suit earlier in time, वादी के वर्तमान प्रकरण को प्रस्तुत करने के पूर्व प्रस्तुत किया था, परंतु वर्तमान वाद में प्रकरण की कार्रवाई को स्थगित करने के पूर्व वादी के पक्ष में यथास्थिति का आदेश पारित हो जाने के कारण प्रतिवादी द्वारा प्रस्तुत किए गए प्रकरण सो एंड सो में प्रतिवादी की ओर से प्रस्तुत किए गए वाद में आवेदन पत्र अंतर्गत आदेश 39 नियम 1 और 2 के आवेदन इस आधार पर माननीय विचारण न्यायालय द्वारा निरस्त किए गए हैं कि वर्तमान वाद में वादी के पक्ष में यथास्थिति का आदेश है. लॉर्डशिप, दिस इज माय रीजन. मैं सीधा इम्प्यून ऑर्डर, योर लॉर्डशिप. द इम्प्यून ऑर्डर, ओनली वन पैराग्राफ ऑन पेज नंबर 68.
Lordship, 68 to some application. 151.
Lordship, the reason for dismissing my application is having no information about the suit. So, Lordship, at best, if my Lord is not convinced to interfere, it can be remanded back to be adjudicated afresh because, your Lordship, I am facing grave prejudice. And suppose, your Lordship, both the suits are consolidated, no prejudice will
Sending
be.
you back there, I will give you liberty that you file proper constituted petition under Article 27 challenging that earlier order. You will have everything in your hand. That is correct procedure. Instead of, because ultimately it is your choice, or you can say that what you feel is right, you are asking for, but it is not good for your client. Again, it will go, again he will say for some other reason, he will say I have no power under 151, or he will say that under 47 rule 1, this does not fall for recalling of the, then again he will come. It's better you take original, you challenge the original order.
Lordship, if liberty is granted, then certainly I can peruse that. I just wanted to bring in before my Lord the prejudice that is being caused to me. And, your Lordship,
So
the fact that no prejudice is caused to them. It is their suit.
That's what I'm saying. You challenge that order on the application of by which they this thing to you sought recall.
18/8/2015.
The order you challenge that order of which you have sought recall.
Lordship, if liberty is granted, I can pursue that liberty. Your Lord.
Application में कब लगा दी तुमने?
Lordship, the difficulty is that in my suit, I'm not able to get any interim protection because of this order. And the MA is with respect to that only, your Lordship.
What you have been doing all these years?
Lordship, we were
10 years.
Lordship, we were genuinely making attempt to impress the court that there is a violation of the status quo order. You please grant us protection. You stop them from developing the land. We have filed 3-4 applications. It is a matter of record, your Lordship. But in being influenced by the earlier stay order in another suit, my applications are not being entertained. There is no order on merits rejecting my application. Every time my application gets rejected for this reason only, your Lordship. That because there is a status quo order in another suit. So we are...
Was for what?
For declaration of title and injunction.
And your suit?
For cancellation of power of attorney and sale deed by which they get the title, by which they claim to get the title. So it's the same thing, your Lordship. There is no dispute with respect to the fact that the subject matter is same. That is why my section 10 was allowed way back. So that is not in dispute. My difficulty is, Lordship, I am in front of you, I am in your hands, your Lordship, because the only difficulty is that my earlier application of section 10 in their suit is kept pending and their 3912 gets decided. That has become the major roadblock in my suit. And Lordship, what prejudice will be caused if both the suits are...
Section 10 was allowed on your application.
Yes, only their own.
Yes, Your Lordship.
So now you want to recall of that?
Yes,
order.
yes.
That is why, Lordship, I'm pleading before this court that I may be allowed. And Lordship, if both the suits are tried together, no prejudice will be caused. It will be in the interest of justice if both the suits are tried together. The finality will be achieved in both the suit. Either their claim will succeed or my claim will succeed. Unnecessarily, we are fighting in two different litigations. They should have filed a counterclaim in the first place. But for reasons known best to them, not disputing that, they chose to file a separate suit in this, Your Lordship. So, Lordship, I am in a very difficult case, I understand, but I am in front of you because the prejudice being caused to me is continuing till now. Again and again, my applications are getting rejected, being influenced by the status quo order in their favor. That is why it has become very much necessary for me to get the stay removed, Your Lordship.
Order sheets were cancelled.
Lordship, in the MA which is connected.
So what your friend has suggested you that the court is going to dismiss this?
No, Your Lordship.
Then?
No, that is for something else, Your Lordship.
That too after practice of 25 years. उसका बेस्ट पॉसिबल यही है कि अल्टीमेटली कुछ नहीं मिलेगा, ऐसे खेलती रहो.
Lordship, in the interest of justice, one opportunity may be granted. If on the next date, if nothing changes, Lordship has already made up their mind, they can pass the order, Your Lordship. Because, Your Lordship, I want to just make out a case of prejudice, Your Lordship. That is why if I
Correct,
can be
but that should be something within some provision of the law. Na?
Lordship, one opportunity may be granted in interest of justice to make out a case. Lordship. I will supply one judgment, Your Lordship.
They supply judgment within 2 days. I have already uploaded 4 judgments and on 151 this cannot be done. 4 judgments. So including Supreme Court and this Honorable Court. Because second petition is also injunction order 151 is challenged. Not exercising 39(1)(2). So all 4 judgments are in respect of 151.
Lordship, in that
supplied
case,
the copy.
it was
a
very
week ago,
difficult.
last week, copy has been supplied by me.
In that case, it was very difficult for me to get them on board, Your Lordship. They were enjoying stay in another MP which got dismissed in May from the same suit. So I got it tagged only so that the requirement of notice can be dispensed.
They have tagged this petition.
Because, Your Lordship, they were...
You do one thing for both of you. It is in the interest of both of you. You withdraw with the liberty to file an application for analogous hearing.
Lordship, then rather than that, the earlier liberty would be more beneficial for me. If I can challenge that order with liberty, Lordship, I can satisfy the trial court the prejudice that is being caused to me.
Inherent powers are there, but supervises jurisdiction and Shalini Shetty light, 9 years, they are seeking liberty of 9 years.
Lordship, with the MA, I'll come to the...
No, I didn't know about it. It is of the 2015 order. That's why I wanted to give you liberty that at least challenge that original order, so something would be given to your client.
I understand.
This order is of 2015 and your application must be 151 in 2025.
Yes, sir.
After 8 years, 7 years.
Then what have you been doing?
Lordship, I have been prosecuting my suit. Admittedly, I've been prosecuting my suit.
So now you are aggrieved by the fact that because in your case the stay has not been granted.
No, Your Lordship, the problem is that in my suit, they had filed an MP which was disposed of in May, in which they were enjoying stay for a year, Your Lordship. After that, I had come in MA, joined them as a party because they were not accepting my notice, and that petition got dismissed in May, Your Lordship, 16th May 2025. So for the past 1.5 years, my suit could not be
dismissed.
Disposed, Your Lordship.
With the directions.
I respect that, Your Lordship. Well, it was disposed with that direction. But Lordship, for 1.5 years, my suit was not going anywhere. They are continuing construction on the land, misusing the status quo order in a state suit, Your Lordship. So, Lordship, my only humble submission is that if I can be granted the liberty to challenge that order, Your Lordship.
What happened to your 39(1)(2)? Have you challenged that order here before this court?
Yes, Your Lordship. The MA is with respect to that only, Your Lordship.
That is in respect of 151. 39(1)(2) they have not challenged. 151 fresh application for stay. This is under challenge and the connected matter. So court rejected that when there is specific provision of 39(2), 151 cannot be exercised. So that is a connected matter MA, not 39(1)(2).
No, Lordship, in that my application is rejected, not for this reason, but for the reason that they have a status quo order in the another suit. That is the reason, Your Lordship. And consistently 4 or 5 applications of mine have been dismissed, Your Lordship, on this ground only.
तो अगर उनके उसमें क्या स्टे है स्टेटस को
Your Lordship, यथास्थिति का order है.
तो
39(2)(a).
तो फिर वो how can they raise a construction over it?
That's the difficulty, Lordship. That's what I want to bring before the court. But the court is
So
getting
why are you
influenced.
not initiating under 39(2)(a)?
Yes, that's what.
Lordship, the difficulty is that any application, whether irrespective of the title of the application, my contents are the same. It is the same.
You yourself is saying that both the suits are same. Either this way you have challenged it or by way they have challenged.
Your Lordship.
Ultimately, the crux of the matter